So just coming, and I mean, it was interesting to listen actually to the retreat section because there's quite a lot of building on the retreat, and that's in the Greenbelt, and yet there's open space here, and the council's not treating it as Greenbelt, and it's excluding it completely. So I think it really comes down to the lack of evidence that they've got. So what they've done is they've done a map of green wedges, and the map of green wedges is incomplete. So the inspector highlighted this at one of the earlier stages of the inquiry, that this was a weakness in their evidence base. But they haven't really got anything to solve that problem. It's a weakness. So the council's got a map of green wedges that is incomplete, but they actually turn this around and invert it and say, if your green wedge isn't on our map, it's not a green wedge. So that's an absence of evidence. It's not evidence. And that's what they're doing here. That's what they're doing here. They're trying to say that, in fact, in the... Shall I just... in the council's own statement to the hearing statement, they talk about including open spaces in the urban area, and this urban area designation is also really just wrong, because what they do here is they say that the urban area can be land can be included in the urban area for several things, and it was mentioned earlier. It can be included. Open space can be included, and it's in the most arbitrary way that you could possibly do it. Sometimes it is, and sometimes it isn't, and sometimes it will be, but sometimes it won't be. And there's no real rationale to why open space is included in the urban area in their designation of what they call the urban area. But then what they do is they turn on its head and say, we've included the open area, so the open area, they treat it as if it's previously developed land or built development, but it's not. It's got areas of open space in it. And in the council's own hearing statement, they actually conclude that the evidence doesn't say why those things are in there, and they just had to make it up as they went along. So that's just completely arbitrary. And I mean, I believe previous inspectors and Secretary of State, I think, has told them that they cannot arbitrarily exclude land from the Greenbelt. But that's what they're doing, because they're arbitrarily including it into the urban area and then saying that the urban area must be removed from the Greenbelt. So that is effectively arbitrarily removing open space from the Greenbelt. So the issue I've got is really this green corridor. Now, the Heslington Village Design Statement identifies that there are green wedges in this area that protect the rural character village of Heslington and prevent coalescence. Now, we've heard several things about preventing coalescence, and it seems that you can prevent coalescence with a shopping centre in Huntington, but preventing coalescence between a neighbourhood area of Heslington and York is not really that important. Well, that's not consistent, is it? And in the middle of this land is a scheduled ancient monument. And of course, we know that landmark monuments are one of the things that should be considered. But the council's extended landmark monuments to actually be anything that they think has got historic value, but they don't think that scheduled ancient monuments, or at least some scheduled monuments do, so they don't include them. So it's become absurd. It's just absurd. There's no real consistency to the evidence. What they've done is they've abstracted it away from being the Greenbelt purposes themselves and haven't bothered to assess the Greenbelt purposes. They've created this methodology that says we can do these other things instead of Greenbelt purposes, and then they've been so selective about the things that they actually include there and don't include, so that the evidence is really meaningless. So there's no real correlation between the things that are being proved and the Greenbelt purposes, the 5 purposes of Greenbelt in NPPF Section 80. And I also think that when the council is using this methodology, And there are two possibilities. If you discover that any site is wrong, there's two possibilities, right? Either the methodology was wrong, or the implementation of the methodology was wrong. Now, fair enough if the implementation is wrong, but if you end up, I mean, there's a lot of people who've been saying a lot of sites they don't agree with and a lot of boundaries they don't agree with. Well, if in any of those cases it turns out that the methodology is wrong, and it's because that methodology doesn't actually act as a true proxy for the Greenbelt purposes, then I think we're going to have one of Karl Popper's black swan moments where we've actually proved that the methodology is wrong. Excuse me. And so I don't think that there's really there isn't really the evidence there for any of these sort of green wedges and green things to be excluded. And I've provided in my evidence base some pretty compelling information as to why they should be included. And I don't believe that York has merged with Heslington, or in this case it's the edge of the university, which is in Heslington Parish. But I don't believe that it's merged there and that we should just ignore it. I think you can walk down that cycle track, which is Susterns Route 66 cycle track, and you're walking through open space that continues on from Wormgate Stray, the same cycle track, moves into the university land on the edge of the university, where it's all open space. It goes past the scheduled ancient monuments, and this is land, it's land that's owned by the university, but it's open space. So the idea is, if the university needs to be excluded from the Greenbelt, which is fair enough, but it shouldn't be treated that any scrap of land that's owned by the university has to be excluded simply because of the ownership of the land. Now, if that was the case, this question about this, is it ST27 that they want to take, they wouldn't need to prove it. They'd just buy it and it would be removed because they would own it. So, I mean, I think that there's probably a case, a very good case, to say that the built-up area of the actual functional part of a university campus, where they've got the accommodation blocks, the teaching blocks, the student community, those probably aren't things that should be in the Green Belt. But there's nothing to say that the land on the very edge of this campus that is acting as a buffer between York and Heslington should actually be removed. And there's plenty of reasons why it shouldn't. So the other thing I'd like to touch on is that although in my evidence, what I've done is I've evidenced a green corridor by going through each of the pieces of land that form up that green corridor and identifying why each of them is a green wedge and a green buffer. Oh, and I just missed out as well that the other piece of evidence that the council has that is ignored is a technical officer's assessment of Site 138 in the local plan assessment. Now, the technical officer used all three of these terms, green wedge, green buffer, and green corridor, in relation to some of this land. So the council's saying it's all merged, there is no green buffer, green corridor, but the technical officer's mentioned it. So the Heslington Village Design Statement's mentioned it, the technical officer's mentioned it, and there's all sorts of reasons why it should be included and should be listened to. Now, although I've evidenced all of this by positively identifying land that should be in the green corridor and therefore should be in the green belt, I've actually come to another conclusion as to how you get the same answer, and that is that we just keep the same green belt boundary that we've got now, because the current local plan is not defining the green belt boundary for the first time, it's altering one. The 1995 Greenbelt Local Plan has got the correct boundary in this location, and the only thing that needs to be changed is that the university needs to be considered a settlement in the Greenbelt and be inset. And with relation to the little bit of development that occurred on 49% of H56, that should probably be inset as well now. Not because it wasn't in the Greenbelt, but because the council's built on that bit and it's gone. But that's the starting point that I think we should have, is that the 1995 boundary is right, and that if the university stuff has to be removed, then remove it, inset it. It's a settlement. There's thousands of students who all live there and do their own thing and are separate from the other communities, even separate from the village of Heslington, which is in the same neighbourhood area. And that's what the green buffers do. The green buffers separate the university from other areas of different character, even when those areas are within the same neighbourhood area. But the green wedges are separating the neighbourhoods. They're separating the neighbourhood. So along the parish council boundary, on one side of that boundary, you're in York, and on the other side of that boundary, you're in Heslington. So if there's open space along that boundary, it must, by its very presence, be preventing those two areas from coalescing. So it must be fulfilling the fourth purpose of Greenbelt in NPPF Section 80. There's no way to get around that if it's actually there and it's contiguous with the boundary, then it must be fulfilling the fourth purpose. And the council cannot be excluding it and just saying, oh, that's coalesced and we didn't have any evidence, but we just thought we'd just not bother to put it in. So, I mean, I know that I've said something quite contentious there about this being the second time that the boundary is being defined. So I just want to lay out a challenge to the council. If the council believes that this is not the second time that this Greenbelt boundary has been defined in the development plan, then I ask the council to provide a copy of the decision by the relevant decision maker that that plan will not be ever adopted at stage 5 of the plan making process. Now, I've done a Freedom of Information request. The council's told me that they haven't got any record of the York City Council having made that decision. I've done a Freedom of Information request of North Yorkshire County Council, and they gave me one decision that they made, and that decision can't be considered to be a decision that the plan should never be adopted. So I think what happened with North Yorkshire County Council is that the plan went to a public inquiry at stage 4 of the plan making process. It passed that public inquiry, it went to the North Yorkshire County Council to make a decision at stage 5 of the plan making process. At stage 5 of the plan making process, it's required for the decision maker to make a decision within a reasonable period of time. And that decision must be a decision to adopt the plan or a decision that the plan should never be adopted. However, an impending government reorganisation meant that North Yorkshire County Council would no longer be the decision maker after that. So North Yorkshire County Council took the following actions. They approved the plan for development control purposes. They updated the plan on development draft, and they notified the Shadow York Authority that they'd done so. They then made a decision, and that decision was that North Yorkshire County Council would make no further action on the plan. But it indicated that there were further actions to be performed by York. So this was not a decision that the plan would never be adopted by any decision maker. It was purely a deferral. It was a handover from one decision maker to the next. However, York City Council, when they received it, seemed to have believed that the decision had already been made and the plan had been rejected. So they didn't do anything with it. All they did was start their own plan and copy the Greenbelt boundaries from that plan into their own plan, which had been copied from plan to plan for approximately 9 years until they removed them in the 2005 plan by error. So what I would suggest is that it's been kicking around for 26 years without a decision having been made at stage 5 of the plan making process. And that the requirement to make a decision at stage 5 within a reasonable period of time has been elapsed, and therefore a procedural error has occurred. If a procedural error occurs, then it must be the case that it must be determined whether or not the plan would have been adopted if the decision had been made. It must be put into the same state that it would have been if a decision had been made. And the fact that the council, the fact that firstly it was at stage 5 of the plan making procedure to start with means that there's a presumption that it would have been adopted because it had gone through a public inquiry. And secondly, the fact that they've used that boundary for so long and they've included it in their plan and carried on submitting it to the inspector at various times, that boundary is one that they would have adopted if they'd made the decision. And therefore, I believe that the Greenbelt boundary in the 1995 Greenbelt Local Plan must be included within the development plan, and that's the correct boundary to start off the assessment of where the Greenbelt boundary should be. Thank you.
You submitted with your hearing statement a number of plans and documents. Do any of those show that boundary that was in the 95 plan? Can you point me to that?
Yeah, so there is one of them that is, it's a section, I haven't included the whole plan, but there is one of them that shows the section of the Greenbelt boundary in this area on the 1995 plan.
Right, okay. So I'll be able to find that within one of the
yes, that's correct, sir.
That's helpful, thank you. I could ask the question of, what do you say that we should do? But I'm not sure that's a fair question. You can answer it if you wish, though. How do you think we should play that? How should we deal with it as inspectors examining this plan?
Yeah, it is a difficult one. I mean, I think that ultimately, I think that if you agree with the reasoning that I've put forward there, and you can check it from records and everything, if you agree with that reasoning, then the current boundary is changing an existing boundary and should have to test exceptional circumstances. I mean, in terms of the particular area of this area, if you are minded to go ahead and try and get if you didn't have to do that I just said, and you are minded to just decide where the boundary should be, then in deciding where the boundary should be, I think it should be in the same location in this section 7 as where it is shown in 1995. And then I think that the main core of the university and that little developed bit that's on H56 should be excluded, should be inset. The 51% of H56 that they've developed. I mean, technically, although development can occur in the Greenbelt, it's probably not serving any purpose to keep that in there. But the main thing is really the university. It's the way that the university, because the other thing that I mentioned, I don't know if I just mentioned it, but when the public inquiry for the university's Campus East came up, it was established that they couldn't develop in order to have the very special circumstances required for Campus East, it had to be established that there wasn't any other land that they could develop. So all of this land on the existing campus can't be developed because the very special circumstances wouldn't have existed for Campus East if that had been the case. So all of this land in the green buffer is just stuff that can't be developed anyway, is open, and like I say, is in that 1995 plan boundary. So, I mean, I guess I can't answer the question for you whether or not this is fatal to the plan, or whether you require the council to perhaps do some more work to start from that boundary and ask them some more questions as to how they exclude land. I mean, it's clear from what the council's produced in terms of their evidence of open space, it's just lacking anyway. So I don't think that what they're putting forward has really explained the way that green infrastructure in York and the Greenbelt boundary should be interacting. So I think there's definitely more work would need to be done there anyway. Thank you.
Thank you, Mr. Wedgwood. Mr. Linus.
Yes, can I deal with a few general points to begin with on development plan? First point is that the only plan that's capable of being adopted as a development plan under current legislation is this one. Second point is that insofar as reference was made to North Yorkshire's work that was undertaken on draft plans there, The simple point is that North Yorkshire doesn't have any jurisdiction to adopt a development plan relating to York. The third point is, insofar as reference was also made to a 1995 plan, you can't proceed on the basis that this plan is unsound simply because the 1995 plan was not adopted. You must look at the processes that have been followed in relation to this plan under the legislation. In relation to the 1995 plan, the point that was being made about boundaries that were drawn for Greenbelt purposes and development control purposes, again, you must look at the up-to-date methodology that is being followed by the Council in proposing the current boundary. The fact that boundaries may have been proposed in 1995 through a draft plan does not affect the methodology that's been applied under current policy as put forward by the Council through this examination, and you must examine and look at those boundaries on their merits through the methodology that we've applied. So that brings me back really to one of the initial points that was made by Mr. Wedgwood, is that effectively you have a Greenbelt boundary that's being changed through this examination. That's not the case. This examination is setting the Greenbelt boundary for the first time, and nothing that happened in 1995 or through the North Yorkshire County Council in previous years affects that. This is the statutory procedure that needs to be followed under this plan. As for other points that were raised, I think standing back from them, they appear to be, in essence, a repeat of points that were raised in previous phases under the methodology, in particular in relation to how green spaces which appear to lie within the urban boundary are dealt with. We set out in previous phases how the scoping exercise for the inner boundary was developed, including looking at the area that was on the edge of the main area of the urban area. We've set that out on page 47 of the topic paper, having reference to density analysis at pages 35 and 36. I've explained the basis upon which we've looked at land around the main urban area, having regard to density of development within it, and we stand by that. In short then, a lot of the points that appear to be raised by Mr. Wedgwood are either points which are wrong as a matter of law or repeat points about methodology that have been covered in previous sessions.
Mr. Wedgwood, was there anything you wanted to add briefly?
Yes, thank you, sir. I just wanted to point out a couple of... firstly, he didn't actually answer the challenge that I set him. If you can provide a document from a decision maker that says the plan should never be adopted, then that's the benchmark. That's what you need to provide, because when a plan reaches stage 5 of the plan-making process, a decision must be made within a reasonable period of time. And that decision can be one to adopt the plan or one that the plan should never be adopted. So if you can't provide a document that says it was never adopted by the decision maker, then it was either adopted or it has gone into a situation where a procedural error has occurred. Now, you're saying it can't currently be adopted. North Yorkshire County Council's got no jurisdiction, it's an old plan. I'm not talking about what happened now. I'm talking about what happened when that procedural error occurred. Thank you.
Can I just make a legal submission? There is no legal requirement to adopt a plan or to give a decision one way or the other. The requirement is that if a plan is to be adopted, that it goes through a legal process, which you know very well. If an authority decides to abandon a plan and to proceed with a new draft plan, which is what happened here, that is a perfectly lawful process. And were it to be open to challenge, it should have been challenged at the outset when the new plan decision was made to pursue the new plan. But there is no issue of law. There is no requirement for a decision such as Mr. Wedgwood thinks needs to be made. And there is no issue in this case of changing Greenbelt boundaries. This is a setting exercise. The boundaries have never been set by an adopted plan. This will be the first time. This plan superseded any earlier drafts that were not adopted, and if it is adopted following your report, then it will be the setting of the Greenbelt boundaries for the first time.
Thank you, Mr. Evan. I'm not sure we can take this an awful lot further, but unless you had a burning desire to say anything else, Mr. Wedgwood.
The only thing that I really want to just respond to that slightly is just that if the council wasn't going to take forward the plan that the inspector had already looked at, then shouldn't they give reasons for it? Have you got those reasons? Thank you.
Yeah, I understand your point. I'm not sure it takes what we're doing very far, but yeah, I understand the point you're making. Is there anything else on inner boundary section 7? Yes, go on.
Just to clarify for any residents in the more rural areas of York that might be looking in on this inquiry, this hearing, sorry. As far as I understand it, planning applications for the last umpteen years have been treated by the planning department in CYC as in a green belt. So for people who are watching, they may be confused about whether we're setting a green belt, whether you're setting a green belt, or whether there is a green belt.
As I understand it, and I'll happily be corrected, I think that's as a result of the regional spatial strategy, or the bit of the RSS that was saved, which does set a green belt of sorts, but it doesn't give a defined inner boundary, which is the task that we're setting ourselves through the examination of this plan. I hope I've got that right.
I was going to say exactly the same thing. Mrs. Hilton, the preserved regional spatial strategy set a general green belt boundary, which I think we debated at phase 1. Therefore, certain judgments can be made, but only in a generalised way, because there's no specific boundary. The specific boundaries only come to be set through this plan. So that's the reason for that approach.
Yeah, it's the general extent of the green belt, and York is, I believe, unique in this country in having only a general extent shown in RSS. That's the regional strategy policy, and having an absence of boundaries holding that general extent together. But you are quite right. The approach that has been taken by the decision-making authorities, both the council and I would say planning inspectors, is, despite the absence of boundaries, to make decisions in that area, applying green belt policy.
Anything else on inner boundary section 7? Is there anything else that anyone wants to raise then this morning, or I'll bring the hearing to a close?
Did you want to do section 8, or do you want to save it to the afternoon, or if no one has anything to say, do you want to just...
Mr. Pilcher, there's an issue with section 8, which Mr. Linus is just going to...
Well, there is an issue, and I'll be completely open about it. My MIQ's only covered 4 to 7, and that was my error. But yes, Mr. Linus, section 8. Can you help us with that?
I may need to take some further instructions, but we note that at least one of the hearing statements that was submitted actually referred to section 8. We know that Mr. Pilcher is aware of the issue as well, but as you rightly identify, it wasn't mentioned in the MIQs. We've been investigating the extent to which there are other representors in relation to section 8. There is a very small number, including some who actually supported the boundary as proposed. There's a very small number, I think.
6.
There's a total of 6, but two were in support. Another one was in partial support, and the remaining 3 referred to section 8, but we're not sure that all of them have actually participated in the examination thus far in any event, other than Fulford Parish Council. So procedurally, I think we wouldn't have any objection if Mr Pilcher was wanting to raise a point on Section 8, but we'd obviously need to discuss the best way of proceeding. One way, again, thinking aloud, is that we're aware that if those other parties haven't participated in the examination thus far, they may not want to participate in any further sense at any hearing. So it may be appropriate to contact them, ask if they're prepared for their representations to stand. If not, then we'd have to look at potentially putting in another part of a hearing session to cover that. And we can discuss with you outside the examination when that might be. One possibility is if they're content to rely upon existing representations, we feed it into the Greenbelt boundary session next week. If they don't take that course, we may need to look at a later hearing session before the wrap-up session in week 3.
Yeah. Either way, in relation to others, I don't think that prevents us from hearing Mr Pilcher today, particularly because we're recording, so people can always see what's been said so far. So, yes, our apologies for that. It does, I'm afraid, boil down to a simple typo of a number 7 rather than a number 8, I think. But yeah,
it says, yeah, and ironically, I actually was not going to make any contribution on it, and it was just following the process of seeing whether we were going to go all the way around the clock face.
Yes, well, Mr Pilcher will anticipate that I was about to point out the fact that his hearing statement doesn't mention
it. Doesn't say anything, no.
It was another participant who hasn't appeared at any of the sessions despite putting in a hearing statement, so those submissions have been made.
In which case then, Mr Pilcher, thank you. I can draw today's proceedings to a close then. Okay, we're back tomorrow at 9:30 when we're talking about university and OAN. So
and we'll forward to Carol the list of those who made representations on Section 8. As I say, it's a short list. Thank you.
So we may to make sure that the option of them not appearing is made clear if they don't think it's necessary to do so.
Good. Well, perhaps we can have a chat about that when we finish. So, yeah, the hearing today is therefore closed. Thanks, everyone.